next case before the court is in re JL, CL, and KL. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. I know that there are 2 of you here today. I will leave it to you to divide your time accordingly. If you do plan to reserve rebuttal time, please let me know, as I'll be keeping the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. And you should not use the names of children or minors or victims during your argument. You can refer to them in terms by initials or by general terms like the child. The judges have read your briefs and are ready to proceed when you are. And I would ask the appellants about whether they would like to reserve time for rebuttal.
Paul Brown, on behalf of the appellant, Desiree Stover, yes, I would like to reserve rebuttal time.
Okay, and you'll divide your rebuttal time too accordingly. How much rebuttal time in total would you like? Okay, very, very good. Then the judges, as I said, have read your briefs and we are ready to proceed when you are.
Thank you very much. Morning, Counsel. My name is Paul Grant. I represent Ms. Desiree Stover, the appellant in this matter. She is the mother of these children. I'd like the court to know at the time of this incident, we were going through COVID in our country. Had a lot of effects on many people in our country, specifically here in Summit County. My client is a cleaner of homes. Your Honors, this is a story of how much she loves her children. She has 3 young children at the time. JL was 7, CL was 8, KL was 5, but they were all going to school. There's a history of false complaints against my client, and the social worker from CSB, Mr. Donahoe, had heard some additional allegations against her, and he went to check out. One of them was whether or not, in the summer of 21, whether or not she was living out of a storage shed or storage location. Police verified that they were not living in a storage location. Mr. Donahoe reached out to my client to see the children and verify her address. She was consistent in letting Mr. Donahoe know that she lived at 880 Iona Avenue in Akron and gave the name of the homeowner as Alex Rogers. By way of history, my client had lived at a number of places over the years, sometimes a year or more, sometimes just a few months. But more recently, she had lived and was verified by CSB in August of 2021 that she had a place to live. It was verified and the case was closed. Then the allegation of the storage unit comes up. It's verified that they're not living in the storage location by police. And then additional allegations are made about mental health and drugs. It'll also be said that the father, Mr. Lowry, doesn't have a very good attitude and expresses himself in a very disrespectful way to everybody, but specifically this social worker. That, I want to really clarify, that is not a factor in how well these children are loved by their mother or cared for by their mother. When we have an initial request to meet my client at the Iona address, Mr. Donahue was there. My client was busy and delayed by the children getting out of school. She calls him, continues to cooperate, and encourages him to come meet with her at a bus station. Mr. Donahoe, because of traffic that he was involved in, decided that he was not going to make it. Okay? But there's still a level of cooperation here, and they rescheduled for September the 2nd, 2021. Just prior to the meeting at Iona, it's about 2 hours prior to that, my client is getting the kids off of the bus, and the father and the paternal grandmother caused a significant situation that they're trying to take the children against her permission. As it turned out, the father and the paternal grandmother have a CPO against each other. They shouldn't be together. But that's not a reflection of my client. My client didn't want them to go with either one of them. Ended up going with the paternal grandmother and the father. And my client called the police. They're in Springfield, and they're at a location called Stop and Shop in Springfield. So she's asking for help to regain her child from the father and paternal grandmother. Well, she calls Mr. Donahoe to say, I have this situation that's going on, and I need to delay our meeting at the house. I'm doing what I can to get my kids back. Matter of fact, Mr. Donahoe testified that that was an adequate, responsible thing to do, to get the police in there, not to do any self-help. So Mr. Donohue is told where they are. They go to the location, and instead of focusing on retrieving from the parents, which was an Akron police job to do, because that's where they were at the time, the focus is on Mr. Donohue filling in the sergeant of Springfield and telling him whatever was on his mind about whatever he had heard and the question of homelessness. There is a video of this encounter, and I encourage everybody to watch this. My client has her 2 young children with her. They are remarkably dressed, pristine dresses, bows in their hair, hair's combed, very, very clean, just bubbly young children enjoying an ice cream and a snack on the stoop while their mother's dealing with this adult situation. They're listening to her, they're interacting with her. There's of no concern for their safety or well-being. You can tell they're well-nourished, you can tell they're healthy, and is from what the record indicates, they had been gone to school and there's no concern about their education, health or otherwise. Christopher shows up later, and you see him on the video, and he's well-dressed after a day of school. He's just there and is not able to really interact with the other people. He's kept aside because by this time the Juvenile 6 has been put into place. And it's only put into place because the officers heard from Mr. Donohue about the effort to go to the house. My client is on the phone with Mr. Alex Rogers in confirming with CSB that that's Mr. Rogers at 880 Iona, and begging Mr. Donohue and the police to go to that address. No efforts were made to go to that address. At that moment before the Juvenile 6, after the Juvenile 6, the next day, or any subsequent days after. The testimony that came out in court is what I've described, that there is no clear and convincing evidence that they were homeless or lacked appropriate care at that
What about
stage.
the admission that she was couch surfing?
Well, Your Honor, that is a term of art. That is not to say literally, I'm couch surfing right here, right today. This was a consistent address they had been at, especially since they had been at another location in August. By the way, Your Honor, couches are pretty nice. And there's no description of whether she's talking literally about a couch or a bed, or what the furnishings were, or what the adequacy or cleanliness or safety about that. It was a comment. It wasn't literal. And because it was taken literally, it still doesn't go to the level of clear and convincing evidence that couch surfing was homeless, or that she didn't have a proper place for these children to clean themselves, to clean their clothes, to get an adequate night's sleep, to prepare for school, to go to school, to take care of their daily activities. There's nothing in the word couch surfing that deteriorates that necessity of daily life for the kids. As a matter of fact, Mr. Donohue clearly said in his testimony, cross-examination, the basic needs of the children are being met on that day. And he has no other proof about any day prior or any day in the future, only in that moment. And that's all he was able to testify, because he failed because he chose not to do his job. And given the cooperation to do so by my client, I want the court to keep in mind that he didn't go to the Summit County Juvenile Court and ask for an access order. He didn't get a search warrant from the police department. My client was voluntarily cooperating. Because CSB chose not to make a record with facts, this case fails, because my client's children were not dependent. I'll reserve the rest of the time. Thank you.
Thank you, counsel. Mr. Medved, I'm going to let you know that you're at 6:21
And
now.
I appreciate that, and see that, and I will be very quick, and I will reiterate just a couple of things Mr. Grant has stated. And I want to be clear about the nature of this case. The thing I want to make clear prior to rebuttal is that this is a burden on the agency to provide clear and convincing evidence that these children were dependent. And the actions of the caseworker and of the police in this matter largely amount to burden shifting to try to place the burden on Mr. Grant's client to establish that these children were not. You will see if you watch the video that the police officer states, contrary to law, that if she does not give Mr. Donahoe access to that home, he will take those children into custody and are JR6. He states that in the record. That is coercive, it is illegal, and it is the violation of almost any right that this mother had. And Mr. Grant is accurate that despite having no obligation to do so without an access order or a search warrant, the mother was willing to open up this home to Mr. Donahoe, had contacted him to make those contacts and make those arrangements, and was on the phone with the homeowner to at least have that conversation. Mr. Donahoe refused and chose not to turn around. Even though that's not the burden, the mother did not have to do anything short of an access order. It was the police's burden to get an access order or warrant. It was Mr. Donahoe's burden to approach the court to say he had probable cause to get an access order to this home. And it is the agency's failing that we are talking about here. They did not present evidence sufficient to demonstrate that these children were dependent. And the use of the word couch surfing, and I provide the closest thing I could find to a statutory definition for homelessness in my brief, does not fit within those things that measure. There is no concern that these children's basic needs were not being met. There's no concern that they were destitute, that they were at risk of any kind of physical or emotional harm as a result of any actions on the part of the mother. My client, the father, was, I think, I'll put it politely, rather aggressive with the caseworker, but my client was not in custody of these children, did not want to be, and I think that aggressive actions and they were not violent, they were just verbal. They do not risk a harm to the children, and he was not seeking custody at that time. So I would see that I would resume the balance of my time for a little while. Thank you.
May it please the court, Kevin Martino on behalf of the appellees, Sunday County Children's Services. We are asking that this court affirm the trial court's adjudication that these children were dependent. With regard to some of what appellants have gotten into here today, we are talking about a juvenile case, not a criminal case. So I just want to be clear about that. So some of the rights that they're talking about, those things were not challenged in the trial court, and they're not at issue because this is not a criminal case. This case started when the agency received a referral in August of 2021, August 18th, that the family was homeless and that they had slept at least one night in a storage unit. It was the caseworker that went to the storage unit and was not able to find any evidence that they were there, not law enforcement. And that was the caseworker following their statutory obligation after a referral is received to see whether or not it's substantiated or unsubstantiated. The caseworker then, on August 23rd, went to the address that was provided by mother, which is 880 Iona. Mother was not there. The caseworker texted the mother the following day. She denied that they stayed at the storage unit. She said she was staying with a friend. And that is another term of art that we see often. I'm not going to get into things that are outside the record, like like terms of arts and other things that were not preserved in the record, but staying with a friend is different than I reside somewhere. Irregardless, there was a meeting set up for the following day, August 25th. The caseworker went to 880 Iona. Nobody was there. Mother then said she had been delayed at the bus stop. In the next few days, the caseworker receives a profanity-laced voicemail from father basically saying you can have the children. Whether he meant that or not, it is still a fact that it's in the record as far as his involvement and what the caseworker was trying to do to verify the address for these children. On the date of the rescheduled visit at 880 Iona, which was September 2nd, the mother contacted the caseworker and said that father and grandmother had taken the children. There was an order of protection in place. The police were called. At that time, when the police arrived, their obligation, they deal with the situation and they want to verify, do these 3 children, when there has been an allegation of homelessness and nowhere for these children to stay, regardless of how well cared for they looked at that moment, is there a permanent residence where they can stay at night for their safety? And mother said she was couch surfing and had been staying at 880 Iona, but she could not give an address of where they were going to stay that night and from then on. So the Juvenile Rule 6 was invoked. That is different than a criminal case where there's some probable cause standard and rights that the council was talking about. The Juvenile Rule 6 allows the police to take a child into custody for their protection or to protect others from that child. That is what was invoked. The following day on September,
Can I
yes,
stop you?
yes,
Is there a definition, a statutory definition of homelessness under dependency?
there is not. There's not a definition of homelessness in 2151. And I did cite in my brief some sections of the Ohio Administrative Code and other definitions of homelessness. And that is all that we have to look at.
But that would be qualifying for other governmental agencies.
Absolutely, that is
Could be completely different than a homelessness in regard to dependency for children.
absolutely.
So there was no evidence of the children not being well cared for.
There was no evidence that they were not well.
And there was no evidence that they had stayed in the storage unit.
There was no evidence that they had spent time in the storage unit. That's correct.
Attorney DiMartino, what about the argument about reasonable efforts determination not being in the order?
Yes. So the statute does require that there be a reasonable efforts determination at adjudication. It is not in the order. Juvenile Rule 40 also says that if you do not object, an issue is waived unless there's plain error, which was not argued. But the remedy would be on remand to have the court make a reasonable efforts finding. Also, there's case law that states it's harmless error if there's been a prior finding of reasonable efforts, which was made at the shelter care. So that is also in the record. So when the child is taken into emergency temporary custody and at the shelter care, there is a finding of reasonable efforts. And I just wanted to go back to Judge Carr's question with regard to the homelessness. At the teen decision meeting that was held on September 3rd, 2021, the caseworker testified at the hearing that mother said she was homeless. And then she said she had been staying with folks on and off. But mother acknowledged that as well. With regard to the 2 sections of dependency under 215104A or 215104C, under A, the subsection is homeless. Even if this court was to find, because there's no definition of homelessness in the statute and the definitions that are in the OAC and in 42 USC 11302, which are very similar when they talk about an adequate place for nighttime stay, essentially. There is sufficient evidence in the record to find that the children were dependent under 215104C because their condition was such, or their environment was such, that warrants the state to assume guardianship because mother could not provide in the time when the referral was made, August 18th, until the time the children were taken into custody of the agency on September 2nd, an address that could be verified of where they were permanently staying. And then she does come in on September 3rd and use the word homelessness to describe her current situation. Her testimony shows that for at least a year ahead of time, they were staying at different places. That may or may not meet the definition of homelessness. The issue was were they homeless at the time the complaint was filed, at the time of the hearing, but it does go to the issue of the condition of the children and whether it was such to warrant the government to step in and to help them and to make sure that they were adequately protected at night. So if you look at a snapshot in time on that particular day when mother called the police because father had taken the children without permission, maybe they were dressed well, all of those things, but that does not mean that the condition was not such to still warrant the state to come in and to provide assistance for these children. Also, there was some argument that sounded like there was this positive environment for these children, and no doubt that mother loves her children, but there is a volatile relationship there with father. That is in the record, and to the point that mother had to call the police because father had taken the children. So if there are no further questions, I would rest on brief and ask this court to find that the trial court was correct, that there's clear and convincing evidence that the children were dependent on the date of the allegations, and also to find that the reasonable efforts finding that was not made was harmless error, and that remand the trial court can issue another decision. The evidence was already before the court as to whether or not there were reasonable efforts that were made by the agency to reunify the children with their family.
Counsel, remind me, on that day when the police were called, was there a request, I seem to recall in briefs, was there a request by mom to have a check after that about where she was living? Could you speak to that?
She did, yes. So the caseworker testified that there was a phone call that came in, and he didn't take the call to ascertain whether or not mom was staying at Iona, because he could not verify that incoming call who it was from, if that person had the ability to actually say whether mom stayed at Iona. And there were multiple attempts to verify mother's address prior to the date.
Was there something though I find something in the record that says, or that indicates that caseworker, for one reason or another, at that point wasn't able to go and verify because of the caseworker's situation as opposed to the phone call? Was there a request to go to the address?
I don't recall any reason why the caseworker couldn't go. The caseworker had already been to the house twice, so I don't recall that. It may be worded differently, and I'm not recalling it right now, but I don't recall any inability for the caseworker to go back to the house. But the child had already been, the JR6 had already been hooked up.
Understood. Okay, thank you.
Thank you, Your Honors.
Your Honor, if I could help answer that last question, the excuse that was given, I had paperwork to do. In other words, now that he has 3 children that's just been juvenile 6, he's got to go back to the agency, and we're talking mid-afternoon by this point. He's supposed to meet at 5 o'clock, this happened around 3, so he still has the whole afternoon and even evening. Keeping in mind, he's already been to the address twice. We already know the location exists. It's just a matter of, can he pick up the phone right there while this young mother is begging him to take the phone call to verify that it's Mr. Rogers so he can make that next move to go down?
How would they be able to verify that it was Mr. Rogers on the other end of the phone?
Well, first of all, you can ask the question. You can verify the phone number. You can verify the address. You can get some kind of identifying information. I don't know, driver's license, social security number, anything. How about, is this you? I'm going to be there in 5 minutes. I'll see you in a second. That is a way to do some investigation. Send Springfield over to that address, or Akron over that address. Where are you right now? There's all kinds of, I'm not an investigator. These are just things off the top of my head. What I would do if I'm trying to help this family, this is what we're trying to do, is help a family to make sure that they're not homeless, so we can make sure the children are going to be okay. Seems reasonable to me. Now, as it relates to the prosecutor indicating that under C, the conditional environment wants the state to get involved here, we're talking about a victim asking for help, about an ex-partner who's causing drama in her life. What do we ask mothers to do, or fathers to do, when somebody's encroaching on their safety and their protection? You want them to act reasonably, and this is exactly what we did, or she did. Your Honor, this...
Is there anything in the record that the mother is hesitant to give out her address because of that situation?
Oh,
With the father?
with the father? well, I don't know if that was in the record, but I am sure that she wanted to limit because of the past drama that they've had.
Council, I just want to alert you that the time is a little bit off. It's about 40 seconds off, so you really only have 4 minutes and 8 seconds.
Thank
I
you.
apologize, the clock got off.
Yeah. And I'll be clear here, and I appreciate the prosecutor acknowledging that there's no definition for homeless as it relates to the Pansy case. But what this court has done is it has indicated that based on Ohio Revised Code 2151.011B1, this court says in dependency actions, you're looking at whether or not the parental care is adequate, not whether it's ideal. We have no proof at all that the allegation was true about the storage, no proof at all about the homelessness. We have a comment about couch surfing, but that couch surfing definition sufficed in August. It is adequate but not ideal in August. It was adequate but not ideal in September. We had the graciousness of help, which a lot of people in our community were going through back at that time in our country's history. Thank you.
Thank you very much.
Thank you. The appellee has stated that these are not criminal cases. They're also not civil cases. This is a heightened burden, and a burden that is placed upon the state and the agency. It is not beyond a reasonable doubt, it is by clear and convincing evidence. It is, and these cases are very much analogous, much more in line with a criminal case than with a civil case where the burdens are equal. It is clear that the burden to prove that these children were dependent in some way is on the agency. That was not done. It's also clear that I would contend that the issues about access and about their inability to get, the failures to get into the home are in the record. Those questions that I asked of the caseworker at the time, that they did not seek an access order, they did not do the things that they would do. And those are issues that are in the record, and you will find them. I would also contend that the Juvenile Rule 6, when you read that rule, you will find that the children can be taken by the police if there are reasonable grounds to believe that these children are at risk of harm. There are reasonable grounds to believe that there is an instance of abuse to a sibling. That there are reasonable grounds for the police to take this child. In this case, there are no reasonable grounds. This police officer took this child because he was trying to coerce entrance into a home that and that is contrary to law. I would contend also that the state has spoken about dependency C, which is something of it's a broad statute, it's a broad section, but even in this case, you must show that there is the actions of the parent, the conditions of the parent are causing some kind of risk of harm to the children, and that is completely absent in this case. There is no indication, there's no evidence in the record, nothing presented by the state that these children spent a night outside, these children were without a home, were without food, were without clothing, were without education. There's nothing in the record to demonstrate that these children were dependent in a way that the agency needed to be involved. And so I would ask that this case be dismissed and the decision of the trial court be reversed. Thank you very much.
Thank you very much, Counsel. Thank you both all of you for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and it will